Hey everyone, welcome to another episode of The Remote Real Estate Investor. I'm Michael Album, and today I'm joined by Garrett Sutton, who is an attorney, investor, and author with over 1 million copies of his book sold. And today Garrett's going to be talking to us about all the different entity structures we should be aware of as real estate investors, as well as where we might want to think about forming those entities because it plays a big role. So let's get into it. Garrett, thank you so much for joining me on the show today. I really appreciate you taking the time.
Thanks, Michael. It's a pleasure to be with you today.
Oh, no, the pleasure is all mine. And I'm super excited to chat with you. I know a little bit about your background and what you do kind of on a day-to-day basis, but I would love if you could share with our listeners who you are, where you come from, and what is it that you're doing in real estate today?
Well, I grew up in the San Francisco Bay Area like you and moved to Reno in 1989. And Nevada is a great state for setting up LLCs and corporations, along with Wyoming. So I've practiced corporate law since 1978 and became associated with Robert Kiyosaki and have written a number of books in the Rich Dad Advisor series and, have enjoyed talking to people around the country, around the world about how to protect your assets. As you start investing in real estate, you need to think about how you're going to protect that real estate because we live in a very litigious society. People sue each other all the time. Mm-hmm. And unfortunately, they don't teach this in school. You have to get this information on your own. And so that's what we provide is the information you need. And then we offer a service to help you protect your real estate and brokerage and other assets.
Love it. And just right off the bat, I read one of your books for our Roofstock Academy book club. It was a great read, so I can definitely vouch for it. But what are the books that you've written? And then talk to us about your most recent book.
Well, I've written a number of books in the Rich Dad Advisor series, including Start Your Own Corporation. That's kind of a foundational one. And then Run Your Own Corporation. A lot of my clients said, I set up a corporation. Now what do I do? And you have to run it properly. Then I also did Loopholes of Real Estate, which is kind of the tax and legal strategies for investing in real estate. And then the newest book is Veil Not Fail, and that deals with the corporate veil. You set up an LLC or a corporation to be protected, and too many people do this themselves, Michael. They just set it up online and they don't realize that there are additional steps you have to take to stay protected. And so if you don't want your veil to be pierced, where someone can sue the company, there are no assets there, they can go through the veil of the company and get at your personal assets. If you don't want that to happen, and that's why you set up an LLC
that's
to begin
the point.
with,
Yeah.
You don't want it to happen. You need to follow these corporate formalities. And so that's what the book Veil Not Fail is about, kind of stories, horror stories of people who didn't follow the rules. And then in the latter part of the book, it shows you how to follow the rules so you can stay protected.
Yeah, great. And where can people find that if they're interested in picking up a copy?
Amazon has it. The Veil Not Fail, it was supposed to be out in April, but we have this thing called supply chain problems. And
I've heard of that.
Not enough paper out there, so it's not out until November.
Okay.
But you can go ahead and pre-order it.
Fantastic. Garrett, let's talk about, I think, a pretty hotly contested and debated topic in the real estate space, and that's LLC versus no LLC. I think, and it's tough because I'm California based. A lot of our listeners are California based. And so to have an LLC in California, you're paying at minimum $800 a year. And with today's cash flow based on some real estate investments, that can eat into your investment pretty significantly.
Yeah.
And so I've heard folks say, you know what, forget the LLC, go get umbrella policy, go get high liability limit insurance and call it a day. Don't worry about it. What are some risks, pros, cons associated with doing that you've seen folks run into?
There's a whole area of law called bad faith litigation. And that's when insurance companies collect the premiums and then find a way not to cover you. All right. The insurance companies have acted in bad faith over the years in collecting the premiums and then having exclusions, the little tiny print that you never read. And so, the insurance companies, let's face it, they have an economic incentive to not cover every claim.
Yeah.
And so they're going to find reasons not to cover you. And so I always recommend that people have insurance. That's the first line of defense. But these LLCs are the second line of defense in case the insurance company doesn't cover you. Or what about a situation where your insurance is, say, $2 million, but the judgment is $4 million, right? I mean, you're personally responsible for that extra $2 million. If the property is in an LLC, they can get what's inside the LLC, but if you've done it right, if your veil is strong, they're not going to be able to reach your personal assets for that extra $2 million. So the idea that you're just going to rely on insurance is, in my opinion, quite naive.
Yeah. Okay. I love it. I'm of the same opinion. I never like to play my hand though, but I love hearing that because I come from the insurance world. So I know how bad things can go. And I also have seen how they're supposed to work.
Right.
But I think you're totally right. There's totally an economic incentive to not pay claims. And the insurance industry as a whole gets kind of wrapped in with the folks that are doing the latter, not the former. So I think it makes a ton of sense. But Garrett, talk to me about, I've heard this concept and this idea that, okay, there's this, you can be overinsured. There is such a point. Now, if I go get a $10 million umbrella because I really want to be protected, does that then put a target on my back for a claim or a plaintiff to say, well, hey, he's got a pretty massive insurance policy. You know, I was only going to sue him for $1 million, but let's go after the full 10.
Well, I mean, there are a number of factors there. I mean, having enough insurance is not a bad thing. If the claim is $1 million, it doesn't give the attorney the right to try and collect 10 million. You know, I mean, the claim is $1 million. So, you know, the fact that you have extra insurance isn't a bad thing. The attorneys, you know, what we like to do, what we tell our clients is you want to have enough insurance to cover any claim. And so you want to have insurance on the property, fire, casualty, all right? You want to have a personal umbrella policy of insurance covering your home and your autos, because I think that's the biggest risk out there is a horrific car wreck, right? Do you need that umbrella policy, a commercial umbrella policy, over your various rental properties? Maybe. I had such a policy for a while, but here in Reno, it got pretty expensive. And so I just have regular insurance on the properties. I have regular insurance for my home and autos, and I have an umbrella policy for me personally. And so you get in that horrific car wreck, there's enough insurance money for the attorneys to get at. They know how to get at insurance monies. They get a percentage of what they collect. And then if everything else is held in LLCs, you know, you'll have an LLC if you own a property in Oregon. You'll have an Oregon LLC on title. You own a property in Utah. You'll have a Utah LLC on title. And then those two LLCs are owned by one Wyoming LLC. That's how we like to structure things. And the attorneys are going to have a tough time collecting from a Wyoming LLC. And so they leave you alone on the LLCs. You have enough insurance to pay the claim, and they'll leave you alone on the LLCs. That's how we recommend our clients structure things.
Okay. And why Wyoming LLC? Because I know you made a very deliberate point of saying where it is formed. What's the point?
There are 3 really good states out there, and they compete against each other to be the best, which is good for us.
That's great.
Right? Instead of having one federal law that applies to every single state, after the American Revolution, each state wanted their own corporate law. And so now we have each state with their own corporate law, and Delaware, Wyoming, and Nevada compete against each other to be the best. You know, the filing fees every year that come in are pretty good. It helps fund the government. So the reason I like Wyoming over Nevada and Delaware is all 3 protect the owner of the LLC. The charging order is the exclusive remedy in all 3. But in Nevada and Delaware, the annual fee is $350 a year. And in Nevada, they list your name on the state website. In Wyoming, the annual fee is $62 a year, and your name does not show up on the state website. So Wyoming offers lower cost, better privacy, and equal protection. So a lot of our clients set up Wyoming LLCs.
Yeah. Okay. Well, I'm sold. So being a California guy, though, this is what I've heard and would love your insights. So I've been told that California, they want their piece of the pie. So I've got to register any LLC that I own in California because I'm a resident here. I live here, even if it has not doing business, because the way California defines doing business is basically me living here.
Right.
So if I own property in Oregon, I own it with an Oregon LLC. That LLC is owned by the Wyoming LLC, but then I got to register both of those here in California.
No, you raise a very good question. So in our example, we had an Oregon LLC and a Utah LLC. And if those were owned by you as a California resident, we'd have to pay $800 twice, once for Oregon, once for Utah. By having the Wyoming parent there, the Wyoming LLC, and we qualify that one to do business in the state of California, you don't have to pay the $800 for Utah or Oregon. So that's a way to save the $800 for all the title holding LLCs. Yes, one of them has to pay the $800 to the state of California. And, you know, California's gotten a little bit looser. You don't have to pay the $800 the first year. That $800 is a credit on the first $50,000 in profits. So it's not like it's wasted. You know, I've had people move from California to Nevada because of that $800 fee. It's just, it infuriates people. Yeah. But there is, if you love living in California, there's a way to work it so you have protection and you don't have to pay $800 for every single LLC you own across the country.
Okay, fantastic. And then in going back to that example, if I've got to register the Wyoming LLC here in California, do I lose out on any of the anonymity that Wyoming affords me because now it's registered here in California?
Yeah, you'd have to list your name in California.
Okay.
Yeah.
All right. Yeah, maybe I will think about moving. Who knows?
Yeah.
All right, Garrett, in your book, and I want to get really niche here for a minute because I've got you. You talk about quitclaim deeds versus warranty deeds. And I think a lot of our listeners out there have utilized this practice or have heard about this practice because if you go get a conventional loan from a traditional bank, they won't lend to an LLC. So you go get the loan in your name, then transfer the property title to an LLC after the fact.
Right.
In the book, you talk about quitclaim deeds versus a warranty deed. Can you give us a little bit of insight into what the difference is and why someone should think about using one versus the other?
Well, the warranty deed or the grant deed says, I warrant that I own this property. And if I transfer it to you and I don't own it for some reason, you can sue me. Okay. All right. So it's a more powerful deed. The grant deed, the quitclaim deed rather, says, I don't know what I own, but I'm transferring whatever I own to you. And the title companies go, well, he quitclaimed that property. And so that severs the title insurance, right? Because he didn't know what he had. And so we're not going to cover him on a quitclaim deed. And so, and too many people pronounce it quick claim deed.
I know.
Quicker, you know, and it's the same deed with a couple different words in it.
Right.
But you really always want to use the grant deed or the warranty deed, because in many cases you sever the title insurance when you use a quitclaim deed.
Okay. And that's even if you're going from yourself as an individual owner to an LLC that you own 100% of.
Right.
Okay. Yeah.
Right. Just ask for the grant deed. Also, if you're buying property from someone, you want to insist on a grant deed or a warranty deed, because if they don't deliver the title that they've promised they are going to deliver, you have the ability to sue them for failure to perform.
Okay. Super good to know. Super good to know. Garrett, as people who are just getting started on their investment journey, I mean, what's the appropriate time to set up an entity? Because I've heard people say, oh, I'll do it later. I'm too small. It's too expensive. You know, what are your thoughts there?
Right at the start. You know, it's just not that expensive. We do not charge a lot of money to set up LLCs for people. It's very affordable. It's a business expense. You get to write it off. But I'll give you an example, Michael. And I've told this story 1,000 times, but I was in San Francisco at an event and I gave a talk about asset protection. And this lady comes up to me and she goes, well, I'd like to transfer title. I just bought a duplex and I'd like to transfer title into the name of an LLC. I go, that's a great idea. I go, in California, it's $800 per year per entity. And she goes, oh, I can't afford that. And so I'm giving a talk in San Francisco again, and she comes up to me and says, I've been sued by a tenant. I'd like to set up that LLC now. Well, it's too late.
Too late.
The tenant rented from you in your individual name. They have a claim against you as an individual, and they can reach all of your personal assets as a result. And once you've been sued or even threatened to be sued, it's too late to set up an LLC. I mean, you can't put a seatbelt on after the accident.
Yeah.
Right? So you really want to set this up right at the start. And I've heard CPAs say, oh, well, just set it up when you can. And that's bad advice. I mean, the joke I tell is that CPA stands for can't protect assets. It's just, you need to set this stuff up right now.
Yeah. Yeah. Okay. I think that makes a ton of sense. And I love the seatbelt analogy. I think that really hits home for a lot of folks. So as someone that's getting more sophisticated with their investing strategy, what tools or strategies should they be aware of as they're starting to scale up in their investing?
Well, I think having that Wyoming LLC as the parent holding LLC is a good strategy. We talked about an Oregon LLC and a Utah LLC owned by one Wyoming LLC. That Wyoming LLC is passive. It's not going to hold real estate. It's not going to do business with anyone. Because if someone sued the Wyoming LLC, they could get at the Oregon and the Utah LLC. That's what the Wyoming LLC owns. So that Wyoming LLC is passive. It doesn't do business with anyone because we don't ever want it to be sued. All right. So that's a key strategy in protection. Now, if your clients are holding brokerage accounts, right? Bank accounts, gold and silver, stock, brokerage accounts in their individual name, the same rules apply. If they get sued personally and they have all these assets at a Charles Schwab account in their individual name, someone can very easily get those. And so what we do is we set up an LLC for the paper assets, for the bullion. And if you get sued in that horrific car wreck, they're in an LLC. It's much more difficult for an attorney to get at those. Because the exclusive remedy in Nevada and Wyoming is what's called the charging order. And that is a lien on distributions. In the state of California, if you own an LLC that owns a piece of real estate in California, the law in California is that the car wreck victim can go to court and the judge can say, yes, you've been injured. You can force a sale of the duplex. All right. And that is not good asset protection. No. So we like Wyoming and Nevada where the court says, okay, you have a claim, but here's the remedy that we offer in our state. You are entitled to distributions that come through the LLC. You can't barge in and force a sale of the real estate. You have to wait for distributions to come. And that's not a good use of the attorney's time. Monitoring if distributions are made. They're on a contingency fee. They get paid when they collect on the insurance monies. So their time is better spent going to the next case that has insurance. So that Wyoming LLC that offers the charging order remedy, not where they can barge in and force a sale of the real estate, but where they have to wait and monitor distributions that go to you, it's a much better system for protection than choosing a weak state like California. Utah is a really weak state. New York is weak. So we have to understand which states are strong and weak and structure your plan accordingly.
Yeah, interesting. And Garrett, talking through all this kind of makes me beg the question of, in our Utah, Oregon, Wyoming, California LLC example, where the Wyoming LLC owns the properties, there is a holding company rather. If the tenant in Oregon falls and sues the owner, I mean, how far does this go and where is the court date held? How does that all work?
Well, if the tenant is renting from the Oregon LLC, that's who they're in contract with. So the claim would be tenant would sue the Oregon LLC. The lawsuit would take place in Oregon, right? That's where the property is. That's where the tenant fell. The action stays within the Oregon LLC. It doesn't give the tenant a right to go down to the Wyoming LLC, which is the parent. It doesn't give the tenant the right to go over to the Utah LLC. That's a separate business entity. So the key here is that if the tenant sues, you want to get notice of that lawsuit as soon as possible, right? You want to turn over this claim to your insurance company so that they can assist in settling the case. Too many people, Michael, have this idea that if they use a land trust where no one will ever know who the owner is and no one will ever serve you is just nonsense, because you want to get notice of the lawsuit as soon as possible. In the land trust scenario, they say, well, geez, no one will ever find out who the owner is. Well, what happens is they go to court and they say, look, we tried to sue the land trust. We couldn't find out who the owner was. And the court says, okay, well, publish notice in the newspaper. So they publish a little 2-point type in the newspaper that we're suing the Oregon LLC, or the Oregon Land Trust rather, and you don't get notice of that either. They go back to court and say, we tried to serve them. We published notice in the newspaper. No one ever showed up. The court says default judgment, meaning the tenant has won. And then when they're trying to collect, you find out that you've been sued. The insurance company can say, well, look, you should have had notice of this lawsuit. We could have defended you, but we're not covering you now. You didn't give us the proper notice. Yeah. And so this whole idea of a land trust and privacy is just nonsense. You want to get notice of a lawsuit so you can turn it over to your insurance company.
Yeah, that makes total sense. I guess it's kind of like the ostrich approach. Like if I stick my head in the ground, I don't see it, I don't hear about it, it's not a problem.
Yeah, it is a problem.
Interesting. Okay. And Garrett, talk to us about some of the different entity structures that are out there, because there's the C Corp, the S Corp, the single member LLC, multi-member LLC. Like, should we as real estate investors be thinking about utilizing some of these different corporate structures, or is really the LLC the kind of Colt 45 of structures?
Pretty much the LLC is the way to go if you're going to hold real estate. In some cases, the limited partnership can work. If you're syndicating real estate and you want absolute control, the limited partnership can work. You're not going to hold title to real estate in a C Corp or an S Corp or any other kind of corporation. Tax-wise, it's just not the best way to go. So the LLC is pretty much, 98% of our formations for real estate are LLCs. The other 2% would be LPs for syndication purposes, or, for estate planning purposes where mom and dad, with an LP, the general partners, which would be another LLC, can own as little as 2% and have absolute control over the property. So mom and dad through their LLC have 2% ownership. The limited partnership has 98% ownership owned by the kids as limited partners, and the kids can't force mom and dad to sell the property. So there are cases where the limited partnership works, but in the vast majority of cases, it's the LLC that is on title to the real estate.
Okay, good to know. Good to know. I had another question for you, and it totally escaped my mind.
Well, how about Fail Not Fail, the new book?
Yeah.
People, these promoters out there just say the wrong-headed stuff about LLCs. They say that you don't need an operating agreement. Wrong. They say that you never have to issue stock certificate or membership interest certificates. Wrong. So you need to treat your LLC like a corporation, whereby you have to follow these formalities. You have to have the annual meeting, right? And the idea that you never have to have a meeting is when you get into a court of law, you're in front of a judge or a jury. I want you to have a minute book with the minutes of every yearly meeting in it. And these promoters say, well, you never have to have a meeting. I want you to walk into court and tell the jury, yeah, I ran this property for 12 years and never had a meeting. It just doesn't work that way.
Not going to fly.
It's not going to fly. So, the reality is when you're in a courtroom. The reality is not when you're in office with a promoter telling you don't have to do anything to maintain your LLC. It's just not accurate.
Yeah.
So that's why I wrote the book, because there's so much misinformation out there about corporate formalities. So with a corporation, you need to follow the corporate formalities. And with an LLC, you need to follow the corporate formalities, because someone suing can pierce the corporate veil on a corporation. They can pierce the veil on an LLC. It's and the rules are not hard to follow. They're really easy. Yeah. It's just if you don't follow them, they can go through the LLC and reach your personal assets.
Yeah. No, that's such a great point. And also, Garrett, I mean, to that point, if someone listening is thinking about reaching out to an attorney for help with either forming entities or restructuring entities, I mean, what are some questions they should be asking and things they should be looking for with an attorney that they want to put on their team?
Well, does the attorney invest in real estate? I mean, I think that's a good question to ask, because, I invest in real estate. I've been through the wars. And so it just helps you appreciate what the client is going through to have done that yourself. Yeah. I think some attorneys specialize in personal injury, in contract cases. I mean, you want someone who really knows the ins and outs of LLCs and appreciates that we have good states and weak states, and that you have to put the combination together to fully protect the client.
Yeah, that makes total sense. And we're recording this, September 2022. What is like the reasonable cost to form an LLC? And then what are any kind of maintenance fees associated with maintaining the LLC?
Well, we charge a flat fee of $795, and then the filing fees are on top of that. So Wyoming, for example, is $100. That $795 includes the registered agent for the first year, so you're not paying any extra for that. We also have a system whereby we keep all your documents. And if you have lost your operating agreement, we give you a portal where you can go on and download your documents. So we kind of have this backup service for you. And then, so you pay the $795 the first year. And then the second year, it's already formed, so everything drops down. You only pay $125 for the registered agent. Now, we give you a book that shows you how to do the minutes, because you really should do the minutes every year. And even though we give you the book with the forms in it, a lot of people don't do it. So we offer a service where for $150 a year, we'll make sure that your minutes are done. And we want to keep you in good standing. We want you to have those annual meeting minutes in your file, just in case. You don't want to be in a courtroom and say, I never had a meeting.
Right. It's too late then, like you said. Yeah. Garrett, this has been super informative. If people want to reach out, continue the conversation, take advantage of your services, what's the best way for them to get in touch?
Well, they can go to corporatedirect.com /schedule and set up a free 15-minute consultation with an incorporating specialist. You'll work with this person all the way through the process, and they'll give you a quote for what our services entail. And, just see if there's a fit. We're happy to talk to you. And so we set up entities in all 50 states. Maybe you set up your entity already. It's an LLC. You don't have an operating agreement. You haven't issued the membership certificates. Don't tell anyone, but we can clean it up for you. We also offer a registered agent service in all 50 states. So if you've got one company here, one company there, we can be your one company to serve as the registered agent in all 50 states. So we'd be happy to help your listeners, Michael, and have them call Corporate Direct or go visit the website corporatedirect.com, and there's plenty of information and articles there, and kind of tells you what we do.
Amazing. Well, Garrett, thank you so much for that. One final question before I let you out of here. We've said the term a couple times, but for anyone who maybe isn't familiar, can you bring them up to speed on what a registered agent is and what the importance is?
Well, the registered agent is someone in the state where you set up the entity or where you're qualified to do business. And the idea is that instead of having someone who's trying to sue you search all over the state of Texas for you, right? The registered agent is an address where someone suing you can go and serve the registered agent with service of process. So it's kind of an efficient way for the justice system to work. It's one place where you can serve an LLC or a corporation, and then they're responsible for forwarding that on to you. And so you want to use a reputable registered agent service that knows the importance of a lawsuit. If we get a notice of a service, we're on the phone immediately to our client because you've only got 30 days to get an attorney and answer that complaint. So you don't want a mom and pop that is going to go out of business or doesn't appreciate the consequences of being served with a lawsuit. So it's an important function. And if you fail to pay the registered agent, they're going to refuse service of process. And then the person suing you is going to go back to court and get, authorization to publish notice in the newspaper. And again, you're not going to get notice of the claim. So you want to have that registered agent on your team at all times.
Yeah, super great point. And the Justice Department looking for efficiencies, that's not something I maybe have ever heard before. So really exciting stuff.
It's something that does exist. So,
well, Garrett, thank you again. This was super informative and definitely would love to have you back on once your book comes out in November.
That sounds great. Thanks, Michael.
Hey, you got to take care. We'll chat soon.
All right.
All right, everyone. And that was our episode. A big thank you to Garrett for coming on. Definitely take advantage of that 15-minute free consult if you're interested. As always, if you like the episode, feel free to leave us a rating or a review. We love to hear from you all, and we look forward to seeing you on the next one. Happy investing.